Welcome, everybody, to this session, USCIS Current Issues. This is Steve Springer, Director of Regulatory Practice Liaison at NAFSA, and we're recording this session on October 5th, 2023, in conjunction with the NAFSA Regional Conferences. Well, I think we probably all prefer to conduct these sessions in person, and we certainly value having agency officials participate in the regional conferences in person. Sometimes that's not feasible, and the next best thing is to record a virtual session. So that's what we're doing today. And there is one significant advantage to virtual presentations, as you'll see in a moment, and that is hearing from far more agency content experts. And today we have quite a few that you'll hear from that have come from USCIS today. The session was prepared by the Current Issues Sessions Working Group, with your input through the discussion forums and networks and IssueNet and other vehicles through which they collected questions and topics. And the NAFSA presenters, Adam Cohen and Hannah Bliss, serve on the Current Issues Working Group. Before we get started, I just want to mention that the slides are available to you. Look for them, look for a link to them on the NAFSA webpage where you access the recording. And I want to mention that you'll notice that we often ask long, wordy, detailed, and highly specific questions, which don't roll off the tongue easily during a presentation. But we do this just to ensure that it's very clear to our agency friends exactly what issue we're referencing and what information we're seeking. We just want to make that very clear so we don't waste their time. And some of the questions, because they're long and detailed, will be paraphrased during the presentation. So if you want to see the full questions, you can download the slides where the full questions will be, and you can follow along, delve deeper into the questions if you want to. And finally, let me remind you that, again, we're recording on October 5th, 2023 in an always changing environment. So please verify any information presented here today before you rely on it. And with that, I'll turn it over to Adam and Hannah to start the Q&A.
Great. Thank you so much, Steve. We're thrilled to be here with our USCIS partners, and we're going to have a good, robust Q&A session. I'm Adam Cohen. I'm with Siskin Susser in Memphis, Tennessee. And Hannah, why don't you introduce yourself to me?
Hi, everyone. My name is Hannah Bliss. I use she, her pronouns. I'm the Director of Immigration Services at Amherst College. Adam, I think you've got the first question, right?
Well, I think before we get to that, Bertho, you were going to, I think, give an introduction as well.
Sure. Thank you so much, Hannah and Adam, for the kind introduction. It's a pleasure to collaborate with you again. I think last time we got together was at the NAFSA Annual Conference in DC. So also I want to take this opportunity to thank again Steve Springer and NAFSA for inviting us to prepare this pre-recording for your regional conferences. Again, my name is Bertha Anderson. I'm the Deputy Chief of the USCIS Office of Citizenship, Partnership, and Engagement. I'm here today with representatives from various USCIS offices and directorates, ready to address some of the questions that you sent us. We look forward to providing meaningful information and sharing some recent developments. While we certainly hope we could have joined your regional sessions in real time, these recorded sessions are a viable substitute as it provides USCIS an opportunity to connect with stakeholders, and in particular with NAFSA. We have a special place in our hearts for you guys, and we want to make sure that we connect with you as you meet during the fall. So strengthening public engagement and improving customer service are top priorities for USCIS Director Urja Du, and sessions like these help us to fulfill our mission. Our session today is a great opportunity for us to reconnect with members of NAFSA from across the regions and provide us with the opportunity to share important updates, respond to your questions, and demonstrate our steadfast commitment to keep these lines of communication open with the organizations. Also, I would like to remind everyone that the information that we are sharing today is intended solely for providing public outreach to our stakeholders. So we are not providing legal advice. USCIS has an important mission, which is to uphold America's promise as a nation of welcome and possibility with fairness, integrity, and respect for all we serve. At USCIS, we believe that a thriving community depends on vibrant businesses, and a key component to this is a strong workforce to include positions at all levels. As such, NAFSA plays a key role here, as some individuals begin this journey in the US as international students. The US has been a destination for top talent from all over the world. Our ability to attract highly skilled workers and entrepreneurs has spurred path-breaking innovation, leading to the creation of jobs, new industries, and new opportunities. We understand the critical role international students play and the impact that they have on our local communities. So we want to continue to encourage them to come to this country in their educational and career pursuits, and we want to facilitate that. Recently, we published a comprehensive menu of options for science, technology, engineering, and math, also referred as STEM, for professionals seeking to work in the US. We also published a similar guide for entrepreneurs seeking to come to the US, including investors, executives, and highly skilled workers. We expanded premium processing to F1 students seeking optional practical training, or OPT, and F1 students seeking STEM OPT extensions. USCIS has also announced the availability of premium processing for applicants requesting a change of status to F1, F2, M1, M2s, J1s, or J2 status. In the months ahead, USCIS plans to issue guidance on student issues in our policy manual. We plan to build on our progress by exploring additional policy and operational measures to continue to improve processing times, our operational work, accessibility, and transparency as an agency. As part of our efforts to increase transparency, we intend to resume publication of our inventory of employment-based adjustment of status applications. USCIS remains committed to serving the public consistent with our values and our security mandate. We take our mission of delivering on America's promise to be a nation of welcome and possibilities very seriously. So thank you for the opportunity to share, to allow us to share some of our updates. Back to you.
Thanks so much, Bertha. And I'll say too, I know you've gotten into some of the policies and items that USCIS has been working on. So I just wanted to ask you as well if there's any other recent developments that you think our community should be aware of, and anything else that's on the horizon as well.
Well, I think we already covered that aspect. Happy to elaborate as we jump on each one of the questions. We have plenty of information to cover, and we want to make sure that we provide detailed information for the international student community, in particular the DSOs, and those who are assisting the international students on campus to ensure that they have the right guidance, and to ensure that they have their stay here in the US, with the proper process, and to avoid any challenges as they have to deal with what it entails having a international student visa.
I think we're ready for the next slide. So this question's about fee increases. In the spring 2023 regulatory agenda, USCIS indicated a target effective date of March 2024 for its final rule. Are there any updates that USCIS can provide on the final rule, maybe an expected timeline for implementation, and what other changes to certain other immigration benefit requirements we can expect to see?
Thanks, Hannah. We appreciate your interest in this important issue. I know it came up back in May during the annual conference. So as you know, the notice of proposed rulemaking published in the Federal Register on January 4th of this year allowed for comments to be submitted from the public through March 13, 2023. So USCIS is thoroughly reviewing all the comments received and considering all the feedback in developing any future final rule. So given that the comment period has closed, we cannot provide any details about the various provisions currently under deliberation. But any updates on the rule will come through official communications from DHS or USCIS. So stay tuned to the unified agenda for any updates with respect to the rule and potential timing. Thank you.
Okay, I think we're ready for our next slide. We're going to start tackling some of the My USCIS tools, customer service in engagement through USCIS and all of their initiatives. As we go through this, I would recommend to our listeners to be aware of where these tools are located, whether they're in the My USCIS account or whether they are other tools that exist elsewhere in uscis.gov. Last week, I think it was last week, I saw this change of address function pop up in my representative account, My USCIS, and was very excited about that. We're trying to find out a little bit more about how this change of address function will work. Will it cover only a particular form and you have to do it for multiple forms? Will it cover all forms that are pending across the board? And what will it mean for the current change of address function that is at the website that we have in our slides as well?
Yes, I can take that one. Hi, my name is Leah Stewart, and I work for the Digital Services Division for the Office of Access to Information Services. We handle the USCIS.gov website. We're also responsible for all these great new customer service tools that we've rolled out recently. In particular, what's called the Enterprise Change of Address Self-Service tool, where customers can see their USCIS online account. They can use their USCIS online account to update their mailing and physical address with USCIS for pending applications, petitions, or requests in that one single place, which then eliminates the need to update the address in multiple places or fill out a paper form AR11, which is the Aliens Change of Address card, or they no longer need to call the contact center or visit a USCIS field office. So the new change of address card the new change of address tool, is available in English only and can be accessed through the USCIS online account, even if someone filed a paper case. So customers who do not have any pending applications, petitions, or requests can also use the tool to meet the requirement of notifying USCIS of a change of address if they move. And just as one note, the current form AR11 posted on the egov.uscis.gov website will eventually be discontinued.
Thank you so much. We're also understanding that an online biometrics rescheduling function is rolling out in My USCIS. And we're wondering if you could describe a bit about how it's going to work.
Yeah, sure. This is another great tool. The new self-service tool for rescheduling an online biometrics appointments allows benefit requesters and their attorneys and accredited representatives to reschedule most biometric services appointments before the date of the appointment. And previously, benefit requesters and accredited representatives could only request to reschedule a biometric services appointment by calling the USCIS contact center. So with this new tool, those individuals who create or already have a USCIS online account can reschedule most requests for biometric services appointments without having to call the contact center. So this new tool, however, cannot be used to reschedule an appointment that has already been rescheduled 2 or more times, or it cannot be used to fulfill a request within 12 hours of the scheduled appointment time, or a biometric services appointment date and time that has already passed. Thank you.
Yeah, may I just ask you a quick follow-up on that? Am I understanding correctly that for these tools like change of address and the biometrics, these have to be for forms that have an IOE or receipt number that starts with IOE? Is that correct?
Well, for change of address, it doesn't matter which form it's for. It's within the account. So whatever form is filed either on paper or online, you're changing your address for that. For biometrics, I'm going to have to get back to you on that. I believe, though, off the top of my head, that if there's a biometrics appointments that's required, that this tool can be used for that, for whichever case it is that's been filed.
Perfect. Thank you. Thank you. We also wanted to ask about just the online filing. In general, we know that there are several forms that are available to be filed online, specifically for our community. 539s for change of status to F, M, and J, as well as F1 reinstatements can be filed online. 765s for OPT, all forms of OPT, including STEM OPT, and some various others. We were curious about some of the sort of our scholar filings, I guess you could say, employment-based processes like I-129s, employment-based green card forms, as well as 539s being extended into H4 dependent benefits. Are there plans for the implementation of these additional forms such that they can be filed online?
Well, we are working on adding the Form I-129 petition for non-immigrant worker to our list of available online forms, specifically the I-129 for H-1B CAP petitions. And we hope to make it available in time for next year's H-1B CAP filing season that begins around March 1st, usually. But at this time, we don't have any immediate plans to announce online filing for Form I-140 or I-485s. So the online I-539 currently supports applications for H4 status, which is the spouse or child of H1, H2, H3, or H2R.
Could you also tell us a bit about some other USCIS functions that are rolling out, such as the text ahead feature for USCIS Contact Center and the new online appointment request function?
Yes, another great tool. One of our 6 tools that we've rolled out recently. So we implemented a text ahead feature in June in English and Spanish. Text ahead will help reduce the number of missed calls from USCIS to customers and their representatives, and that will improve customer satisfaction. We developed it because we found that when we were calling people back that they weren't answering their phone. And there's a lot of reasons for that. Sometimes people, are not able to answer their phone at that time, or they walked away from their phone. It was simply a missed call. So this tool was developed in response to that. Text ahead will personalize the caller's experience by giving the caller the ability to respond by text if they're available to receive a call from the USCIS Contact Center within a certain time frame. It's usually between 30 minutes and 1 hour, and will communicate directly with the USCIS Contact Center representative. The online appointment request form will allow individuals or their legal representatives to request an in-person appointment at a USCIS field office. So another really great tool is the online request. We have a new online request form. So in addition to text ahead, applicants can request an in-person appointment at a USCIS field office for things such as an addit stamp, emergency advance parole, and an immigration judge grant. So individuals can request a specific date and time for an in-person appointment, but USCIS cannot guarantee that the requested appointment date will be scheduled. USCIS will review the guarantee that the requested appointment date will be scheduled. We'll review request and we'll decide if an in-person appointment is necessary. We'll confirm and reschedule that individual for the in-person appointment. We may contact the individual to confirm certain details of the request by phone or email. And we launched this appointment web form tool recently in, I believe, August.
So wanted to talk with you all also about an expedite request tool. I've mentioned this one before, and I'll probably keep asking for it, for pleading for it. So I think it's helpful to kind of paint a picture to everyone on terms of like just the experience of using or placing expedite requests currently, right? So currently, there isn't really any e-request tool for this. So we have to go through the USCIS contact center, whether we're calling or we're using Ask Emma, for example. And it can be difficult based on volume and based on prompts to reach somebody at the contact center and to move through Ask Emma as well. The other side of it is that for contact center through phone call, you're basically stating and making your case for the expedite request, but it's not necessarily going to be, the argument's not necessarily going to be distilled the way that you wanted it presented to the adjudication officer. And Ask Emma, you can type it, of course, yourself, but it's also character limited as well. And through neither of these options are you able to really upload any type of supporting documentation. So, sometimes we'll have like a letter from an employer or some other, important documentation we really wanted USCIS to see, that we wanted to be able to upload in it. We might get a denial of the expedite without having had a chance to do that. And so wondering if you all have considered an expedite request tool that would allow customers, attorneys to fully document the basis of the request and maybe upload that supporting documentation in advance, and thereby also reduce call volume to the contact center as well.
Yes, great suggestion. So USCIS agrees with the notion of utilizing new technology solutions for submitting expedite requests. And this would allow the process to be streamlined, which we like. It would also allow for tracking and could simplify communications between different USCIS offices. For example, our contact center and field offices or the service centers. The work to develop an online mechanism to submit expedite requests, including the ability to upload evidence, is completed, but it is pending a Paperwork Reduction Act review. So it is on the horizon.
Wonderful news. Sorry, back to you, Anna. I just wanted to say wonderful.
I believe this is our last My USCIS question, and it's about the My Progress Tracker functionality, which was rolled out over the summer around the time that these questions were generated. And it's reflective, of course, of the time and space that we were in when we generated them. And this will come up a few times that we might have some questions that are a little less timely now, and we're very timely at the time. But when the My Progress Tracker functionality was rolled out over the summer, some F1 students who'd applied for OPT received some notifications that they would require biometrics. And so the question here is, can you clarify that biometrics are not required for F1 OPT applications? And also perhaps something that would be more helpful now, is there anything that you can share about this potential hiccup, or maybe even anything with the case status info right now that we're seeing in this moment? Some folks are reporting maybe some funky stuff happening there, but I'll open the floor with whatever makes sense for you to share.
Right. Thank you, Hannah. So I did see some of that cross traffic in my own email box in the early summer, and we have made great strides since then. We have worked really hard on My Progress. Through each iteration, it has only gotten better, but I can confirm that there are no new biometrics requirements for F1 students seeking employment authorization based on OPT. And the process for adjudicating the F1 OPT, that remains unchanged as well.
All right, I think with that, we can shift over to our next segment of questions, which are all about optional practical training, or OPT. And the first question is about withdrawals. There are instances sometimes where an F1 student would really benefit from having their withdrawal processed in a super speedy manner. And so we're wondering if there's any case in which a student in a circumstance like this could request an expedited processing of a withdrawal request.
Yeah, hi. I'll go ahead and take this one. My name is Robert McLean. I'm an education officer with SCOPS HQ. Um, Withdrawals are prioritized when sent through the designated school official mailbox, which is also the DSO. A student may also submit a withdrawal through their USCIS online account, but these requests will be processed at the time of adjudication.
Sometimes students encounter errors found on their EADs after applying for OPT. These errors often do not reflect any erroneous information from the I-765 itself. Instead, they often appear to be typographical in nature. Could you walk us through the exact process that applicants should follow if their EAD contains a USCIS error?
Yes, a student may report an error to their DSO or send back the EAD by filling a form I-765 without the filing fees. Identifying the error and providing an explanation as to why the student believes it is an error is generally what we require. If the student needs more information about this process, they can visit the updating or correcting your documents webpage, which will explain the process in more detail.
And what are the steps of the correction process?
Well, the cases are normally processed in a first in, first out basis. The Potomac Service Center, which is also known as a PSC, tries to expedite the request as they receive them. They do recommend also that the student may allow up to 30 calendar days before following up.
And I think you've answered this in your previous answer, but after submitting an initial request for correction, how long are students expected to wait before following up?
Well, we recommend the student waiting 30 days before following up.
Are students expected to mail in their EAD in order to have it replaced with a corrected EAD?
Yes, students must mail in their EAD with proof of error to have the EAD corrected. Specifically, they must submit the original card containing the error, a detailed explanation of the card with the error, and supporting documentation of the correct information. Submit this information to the Service Center or the NBC, which is the National Benefit Center, that approve your last form I-765.
And is there any way for applicants to be able to monitor the progress of their EAD correction or to have a sense of where they are in the process?
As of now, no. Currently, applicants are not able to monitor the progress of the EAD correction. However, USCIS is currently exploring options to allow applicants to track correction requests for cards that contain errors.
Thanks so much. Our next question is about EAD production issues. And earlier this summer, at the time of this writing, many students approved for OPT found that their EAD cards were not being issued as quickly as they'd expected. Some students reported hearing about an EAD production issue that may have been responsible for the production delays. Can you share what the post-approval EAD production process looks like and what types of production issues can impact the issuance of EADs?
So currently, there are no delays. Um, but once cards are approved, they are sent to the printing queue. It typically takes 2 to 3 weeks for the EAD to be printed, shipped, and delivered.
How are EAD production issues communicated to applicants and stakeholders when they do happen?
There are currently no EAD production issues. Any issues with production would be communicated through the public communications, such as web alerts on our website and stakeholder messages.
Sometimes students report that delays in receiving their EADs after being approved for OPT have negatively impacted their employment. In the case of EAD production delays, might USCIS ever consider offering I-9 flexibilities that would allow temporary completion of the I-9 with an alternative documentation?
So thanks for that question, Hannah. Hi, everyone. I'm Shannon Sletter. I'm with the USCIS Verification Division. We administer the E-Verify, I-9, and SAFE programs. And so, yes, I think the answer to your question, Hannah, is USCIS will consider options for acceptable documentation that students may show to complete the Form I-9 while they await their EADs. Thanks for the question.
So let's get into a little bit of premium processing discussions here. And we certainly want to commend USCIS on this expansion of premium processing for, of course, F1 OPT, and then more recently changes of status to FM and J. At the time that we drafted these questions, premium processing, especially for the change of status, was pretty new. So we wanted to see if there were any reflections, wisdom that USCIS wanted to share about the implementation of this expansion.
Thank you, Adam. My name is Brendan McCarthy. I'm a adjudication officer with Service Center Operations Headquarters. We did experience a few minor system issues with the implementation of premium processing. However, those issues were quickly addressed and the process is now working as we had intended. Since deploying the premium processing for change of status to FM and J status, we've had more than 1,000 requests for premium processing.
And I wanted to follow up a little bit too about, how the introduction or will the introduction of the premium processing impact these general 539 processing times for the change of status, particularly the change of status to FM and J?
Yeah, great question. Generally, there will be no impact to the I-539 processing time.
And yeah, I just wanted just a reminder to everyone, if these are available to be filed online as well for OPT and for the change of status. And just remember to file, if you're doing the premium processing, and I'm sure USCIS would back me up on this, but just make sure that you are submitting the 539 and the I-907 the same way, right? So it's either filed online together or it's filed by mail together, right? The other thing I'll mention that I think is kind of helpful there is the removal, and I wanted to also thank USCIS for this as well, is just the removal of the $85 biometric services fee and the biometrics for these 539 filings, which will definitely be helpful because the premium processing was dependent, that 30 calendar day processing time is dependent on the completion of the biometrics. And now with that being removed, that's going to help a lot also with the flow of things. So thank you. I think we could move on to our next slide as well.
When we last saw each other, it was, in May in DC, and DSOs and students were so thrilled to see the return to very reasonable processing times for OPT and STEM OPT. And following the introduction of premium processing, DSOs started to notice a bit of an increase in OPT processing times. Can you share any insight into what may have caused this slowdown?
Sure, Hannah. We are not aware of any slowdowns that would have caused an increase in the OPT processing time.
So let's talk a little bit about, while we're on the subject of premium processing, we can talk a little bit about something on our collective wish list, which would be premium processing availability for reinstatement. And we've communicated with you all a few times about this, and we understand that reinstatement was not originally considered in terms of being eligible for premium processing. So we would just we would reinstate our desire for that and wish for premium processing to be available. And we did want to ask if this is something that is being considered by USCIS to have that availability for premium processing for reinstatement.
Sure, Adam, that's another great question. We do make every effort to process the Form I-539 in the first in, first out order, or FIFO order. But we do acknowledge that processing times for many of the 539 classifications became severely backlogged beginning in early 2022. Since that time, the service centers have made significant progress to reduce those backlogs and continue to provide resources and offer overtime to staff to help continue those efforts, and despite the necessity of prioritizing other form types.
Just to follow up real quick too, Brendan, so do we think in terms of just the availability of reinstatement for premium processing, is that something that is being considered by USCIS, or is it more just at this point a focus on reducing general processing times?
Thank you for the question, Adam. Again, we are continuing to explore premium processing for the I-539 reinstatement applications, while we continue to leverage resources to improve efficiencies in the overall I-539 workload. We understand the benefits of expanding premium processing to this subset and intend to further explore this option in the new fiscal year.
Thank you, Brendan. And I'll say also, just to USCIS's credit in terms of having the online option available for reinstatement can certainly be helpful, not in terms of necessarily like faster processing, but it allows for you to get a receipt issued quicker, avoid the lockbox. And just to that, I would just ask you all, a lot of times with reinstatements, students want to use counsel because of just the complicated nature of it. But 539s are not yet, attorneys can't enter a G28 for I-539s filed online for reinstatement. So we would ask, and I think my understanding is the service is looking into this as well in terms of prioritizing. So thank you. The next question is actually something I believe you all have already answered. There was at least a statement from the ombudsman in August 15th that basically said that the production of EADs is separate from the 30 calendar day processing times for the OPT adjudication, the 765 adjudication. I wanted to just make sure with you all if that is current policy and if there's anything else that you all want to add about that.
Sure. USCIS does not generally consider expedite requests for petitions and applications where premium processing service is available to include those for EAD production. An officer has 30 days to adjudicate a case, and once adjudicated, the EAD is produced as soon as feasible.
We're now going to move on to some questions about special student relief for off-campus employment. In the interest of time, I won't read this whole slide, but to those listening and watching, there are amazing NAFSA resources about SSR. So if it's not a term that's familiar for you, you can catch yourself up quite quickly. There is an increasing number of SSR notices. At the time of this writing, there were 13. That number has only grown in the time since. So as DSOs, I think many of us are catching ourselves up to speed on what the processes are to support our students through these applications, which is why we have some questions for you. So our first question about special student relief is about EAD notations. Earlier this year in the summer, when we were generating these slides, we were getting reports of some errors in notation on the EAD that were specifying 20 hours a week full-time during vacation, even though the 20-hour per week restriction while school is in session is expressly waived under the SSR notices. And in previous engagement opportunities, USCIS has confirmed that these notations were printed in error. And so what we're wondering today is if USCIS has taken steps to remove that erroneous notation when processing SSR EADs moving forward.
Yes. USCIS has taken steps and implemented enhancements to add the SSR annotation to the EAD and remove the terms and condition for the 20 hours per week language from the EAD.
That's great news. Thank you so much. And the next question, also about SSR EADs, this time about duration. When we generated this question, we didn't have the updates that we have today. We wanted to ask you if you were working with SEVP to make sure that the functionality within CVIS would actually allow DSOs to recommend SSR for more than a year. And fortunately, in early August, we received news from SEVP that they've done just that. So I no longer have to ask you if you're coordinating with SEVP to make this change, but I guess I'll just open the floor if there's anything else you'd like to share about EAD duration for SSR.
Yeah, sure. USCIS has implemented enhancements to allow the special student relief employment recommendation to be issued for longer than a year. However, a DSO can still make the recommendation duration clear for USCIS by annotation in CVIS and on the I-20.
Excellent. And we are so pleased, as we've already expressed, we're so pleased to see more and more categories available for online filing, specifically of I-765's OPT for our students. Are there any plans to introduce an online I-765 option for SSR or severe economic hardship?
Anna, thank you for that question. We continue to explore expanding online filing for additional I-765 categories, while leveraging resources to improve efficiencies in the overall I-765 workload. We do intend to further explore this option in the new fiscal year.
Wonderful. So we're going to move on to a few more reinstatement questions. And really, it's just kind of starting with what you all already know about pending reinstatements and the processing times and the impact that can have on students who are finishing their degree and they're looking to either transfer to another degree or maybe even start their OPT work authorization. So that said, I think we should progress to our next slide to actually the particular questions on this matter. So it was interesting, earlier this year, there were some helpful FAQs from SEVP. And then there were also, at the annual conference, USCIS addressed this in a question as well. So there's some very good materials available through the SEVP FAQs and through the minutes, and we appreciated USCIS providing that in writing. So it's basically this idea where even if you have an I-539 that is pending with an I-20 that is issued from particular school, the student may still be able to transfer even while that 539 is pending. And the reinstatement can be basically canceled by the transfer out school, and the transfer in school can then enter a reinstatement request in CVIS. USCIS basically indicated in their question and answer that they would need an updated Form I-20 and a letter from the DSO to support that transfer. So we basically wanted to ask just generally how USCIS is implementing this change in guidance and this transfer procedure. And if there's any way that you all could also comment on what's the best way to provide that I-20 in the letter from the DSO in the course of this process to have that transfer acknowledged while the 539 is pending.
Thank you for the question, Adam. For a reinstatement, if a student continues to be enrolled in a full course of study and USCIS has evidence that a new Form I-20 from the transfer in school, as well as a letter from the DSO indicating that they support the transfer to the new school, students may transfer to the new school while the reinstatement request is pending. USCIS will approve the reinstatement if otherwise eligible. However, if the student no longer is enrolled in a full course of study at the transfer out school, USCIS will only approve the reinstatement request, again, if otherwise eligible, for reinstatement to the original school. Only after the reinstatement request is adjudicated can the student make a request to transfer to a new school.
And our last reinstatement question is actually about eligibility for OPT. And as we've discussed, sometimes reinstatement applications can take a while to be adjudicated. And for students who are nearing the end of their program, this can be a little dicey because they might be coming up against their OPT eligibility window, and every day might really matter in terms of whether or not they'll be able to stay in the US and work as planned. Previously, USCIS would sometimes expedite reinstatement applications as the student was nearing the end of their final semester when requested by a DSO, so that the student would be able to apply for OPT, but this practice has since been discontinued. Is this something that USCIS would ever consider reinstating?
Thank you for the question and the suggestion, Hannah. We at USCIS strive to prioritize caseloads with sensitive timelines, such as reinstatements, and try to do so as much as possible. However, we also must maintain case processing in that first in, first out FIFO fashion. We can certainly understand the concern and can take this back for further consideration.
Thanks so much. And processing times, I'm wondering if you could take us a bit behind the scenes to help us better understand the variation that we see in different forms processing times. What factors affect USCIS's operational decisions that may result in a 3-month processing time for one form versus a 23-month processing time for another? And how are processing time goals identified and prioritized?
Yeah, that's another great question, Hannah. Goals are set with the coordination from the Office of the USCIS Director, and those decisions and goals are made by taking into account a number of factors, including administration priorities, obligations arising from litigation, pending inventories, agency resources, and the urgency relating to the type of request.
Our next question is about I-9 flexibilities. While the COVID flexibility in complying with the requirements related to Form I-9 was greatly appreciated, we know that this flexibility ended in July of this year. And in August of last year, DHS published a notice of proposed rulemaking to create a framework that would allow alternatives to current I-9 requirements. Can you provide a general update on that notice of proposed rulemaking and a possible timeline for implementation of a final rule?
Thanks for the question, Hannah. The final rule, titled Optional Alternatives to the Physical Document Examination Associated with Employment Eligibility Verification, Form I-9, published on July 25th, 2023. Along with the rule, there was an authorization notice of the alternative procedures, which were titled Optional Alternative to the Physical Document Examination Associated with Employment Eligibility Verification, Form I-9. The good news is, for all those words, the rule and the associated notice provides an availability date of August 1st for E-Verify employers to begin remotely examining Form I-9 documents under the DHS authorized alternative procedure. Next slide.
This is about a question about revocation notices for H-1Bs. For students on OPT who were selected in the H-1B lottery and have an H-1B petition approved before October 1st, but then either leave or are dismissed from that position, revocations of the approved H-1B don't feed into CVIS, which can result in the CVIS record being auto-completed on October 1st. The CVIS help desk will not return these records to active without a copy of the revocation notice from USCIS, but we know that students don't currently receive a copy of that revocation notice themselves, and it can be quite hard for them to get a copy of it. There's also a bit of processing time to have the revocation notice issued. And these consequences can be really impactful for students who potentially are losing the remainder of their optional practical training for really just a paperwork issue. Would USCIS ever consider other options for delivering revocation notices on a reliable basis, or maybe consider making the copies available to the beneficiary, in this case, the student?
I can go that question. My name is Evan Hughes. I'm an adjudications officer at Scouts HQ. I work on the H-1B and review portfolios. The student as a beneficiary of H-1B petition does not have administrative standing on an I-129 petition. Because the petitioner is one with administrative standing, USCIS notices pertaining to an H-1B petition are only sent to the petitioning entity and or the petitioner's attorney of record. Unfortunately, under the existing regulations, USCIS may not send a copy of the H-1B revocation notice to the beneficiary of the petitioner.
Next question, we're increasingly veering into the scholar space on these questions. And this one actually pertains to the bundling policy that was, we appreciated hearing the early 2023 update on this, whereby H-1Bs, particularly relevant to the academic community, H-1Bs, H-4s, and H-4 EADs would be bundled together, simultaneously adjudicated, essentially, whether by regular processing or by premium processing, if they were all bundled or filed together. Since this question was asked, there have been some alerts and information that's been posted on USCIS's website on the I-129 page and also on the premium processing eligibility page. Does USCIS envision posting this anywhere else, such as the USCIS policy manual?
Premium processing is not available for Form I-539 applications filed for dependents of the Form I-129 beneficiary classification. However, applications for change of status or extension of stay properly filed together with the Form I-539 for the derivative H-4 or L2 status will be adjudicated at the same time as the principal's Form I-129. This means that an officer will review the H-4 or L2 derivatives Form I-539 as soon as possible after reviewing the principal's Form I-129 and will take appropriate adjudicative action. For example, issuing approval, denial, RFP, void, or refer for an investigation. After that adjudicative review, when the derivatives Form I-539 is packaged together with and properly filed at the same time and in the same location as the principal's Form I-129. Individuals applying for the classifications may request expedited processing on a case-by-case basis. For more information, we have some webpage updates at our options for terminated workers page and how to make an expedited request page on USCIS.gov.
Thank you very much. The next question pertains to the H-1B registration system, which is most relevant. I mean, it has to do with CAP subject H-1Bs, right? So it's not as relevant in academia, except for the fact that student advisors need to be aware of this process when they are supporting their student population. And now we have the electronic registration system for like the last few fiscal years. And so we're interested in a general overview from USCIS about this. There's also this matter that has also been recognized by USCIS of this substantial increase in multiple eligible registrations in this registration process, right? So namely that multiple employers have filed registrations for a single employee, which is permissible, but it's such a large increase that even USCIS has acknowledged that it raises serious concerns that some have possibly gained an unfair advantage or tried to do so by submitting multiple registrations. So we're wondering also how USCIS is addressing this
That's a great question, Adam. The H-1B registration system was introduced in fiscal year 2021 as a requirement for petitioners seeking to file on H-1B CAP subject petitions. Rather than submitting full paper petitions to enter the H-1B CAP selection process, petitioners now submit a registration through their USCIS online account. This saves both the petitioners and USCIS time and money, as petitioners no longer have to prepare full petitions in advance of the H-1B CAP selection process. And USCIS no longer has to take hundreds of thousands of paper-based petitions that must be rejected and returned if not selected. The user experience for the H-1B CAP electronic registration process has continuously been well received by the users. They provided a high satisfaction score with the system for each year. Fiscal year 2024 CAP just had a user score of 4.84 out of 5. During the registration period for fiscal year 2024 Beacon BPAP, USCIS saw a significant increase in the number of registrations submitted compared to prior years. Generally, USCIS saw an increase in the number of registrations submitted, the number of registrations submitted on behalf of beneficiaries with multiple registrations, and the numbers of registrations submitted on behalf of unique beneficiaries with only one registration. We saw upward trends in the fiscal year 2022 and the fiscal year 2023 H-1B registration periods as well. The large number of eligible registrations for beneficiaries with multiple eligible registrations was much larger than the previous years, has raised serious concerns that some registrants may have tried to gain an unfair advantage, such as working together to submit multiple registrations on behalf of the same beneficiary. This may have unfairly increased their chances of selection. USCIS remains committed to deterring and preventing abuse in the registration process and to ensuring only those that follow the law are eligible to file an H-1B CAP petition. The H-1B program is an essential part of our nation's immigration system and our economy, and USCIS is committed to implementing the law and helping meet the ever-changing needs of the U.S. government.
For good measure, we'll throw in a J1 waiver question as well. This one, waivers of J1 waivers of all kinds take quite some time with lengthy processing times, and no objection waivers are no exception. USCIS's portion in it is pretty small altogether. It has to go through several different agencies, but we're wondering, particularly sort of at that point where there is a change of status or adjustment of status, what would be permissible. So I guess the first question I had is just, what are the average adjudication times for the Form I-612 for a no objection waiver when it finally gets to USCIS?
Yeah, Adam, I can take that one. Currently, typically, the adjudication takes approximately 2 weeks. Once we receive the no objection statement, USCIS is open to expediting the case. However, applicants must formally make that request for expedited treatment, and they can go to our website and see how to make an expedite request on our webpage at uscis.gov.
Thank you, Brandon. And quick follow-up on that. Where the timing is a little bit tricky, and maybe the individual has a deadline expiring J1 status, for example, will USCIS allow for a petition to be filed with only the no objection statement or the no objection statement and the DOS recommendation?
Yes, and they can also file that petition without the change of status, but it cannot be approved without a favorable recommendation from Department of State, DOS, and otherwise it would be a split decision.
Now we're going to shift gears a little bit for some super fun information systems integration questions. The first one is about claims data, which is OPT processing data. DSOs rely really heavily on claims data that feeds into CVIS, reflecting the status of students' filings with USCIS. And at times, claims data has been a bit unreliable or sometimes delayed. Can you share how this data flow from USCIS to CVIS works and what would cause a delay in this flow?
Yes. Hi, everyone. My name is Natasha Kirk. I'm a community relations specialist at USCIS. So USCIS did experience a delay in the transmission of data from claims to CVIS, which occurred in November of 2022. The delay was due to a technical issue that has since been resolved. There have not been any more reported instances. Since this occurrence, additional monitoring and notifications have instituted to ensure timely transmission of data to CVIS. USCIS is going to explore avenues for DSOs to directly report any issues they may be experiencing with USCIS data being displayed in CVIS, but we need to discuss the best approach to this with our technical team leads across the enterprise.
And now we have another claims question specific to change of status data and cap gap. Traditionally, claims has pushed information to CVIS in the case of F1 students with pending or approved change of status to H-1B applications. This information then triggers the application of a cap gap extension to the student's F1 CVIS record. When the claims procedure does not properly flow, the CAPGAP extension is then not automatically applied, and the DSOs have to pursue a correction with a CVP, which becomes quite time consuming when multiplied by the number of students needing the correction. Does USCIS have an update on efforts to sync this particular claims data with CVIS?
USCIS is currently meeting with the CVIS team monthly. As of a few weeks ago, on September 19th, the CVIS team is still discussing the requirements internally, and they will share these requirements with USCIS for further consideration once they're finalized. Thanks, Hannah.
Thanks. And another claims question, this time about change of status and consular processing. Similarly, each year on October 1st, and we're recording this on October 5th, so this is fresh and all over our DSO minds. Every year in early October, DSOs find a striking number of their F1 student CVIS records have erroneously been closed or auto-completed because the CVIS system did not accurately capture that their H-1B was approved for consular processing and not for change of status. Can you speak to the claims data and why it doesn't always reliably convey whether an H-1B approval is for consular processing or change of status?
Yes, USCIS works with the CVIS team on information sharing between the two systems to continually improve the exchange of relevant data. We certainly understand the concern and can take this back for further consideration. Thanks, Hannah.
And our last data question is about SAVE. Many schools report issues that students have with Social Security Administration and State Registry or Department of Motor Vehicles based on incorrect data in SAVE. This primarily impacts those who've been approved for change of status or those who were approved for OPT and then changed degree levels or completed a CVIS transfer. SAVE pulls data from the previous status or the previous OPT segment rather than the correct information from the current and active new CVIS record. Is USCIS aware of these data issues with SAVE?
Thanks for the question, Hannah. So NAFSA did raise this concern with USCIS in May, and upon notification, the SAVE team researched and didn't see these issues when we were analyzing case data in response to the inquiry. We also received a second inquiry on the topic and again reviewed systems data as well as feedback from a number of stakeholders, and we were unable to find the same issues that were being reported and described by NAFSA. We always do welcome additional examples of case information that would allow us to further research the issue. But in the absence of that, we have been unable to replicate the problem that was raised with us. Thank you.
How does USCIS data feed into SAVE?
So for those of you who may not be familiar with SAVE, SAVE is an online information service for authorized federal, state, territorial, tribal, and local benefit issuing agencies. It allows those registered agencies to verify their benefit applicant citizenship and immigration status. SAVE verifies immigration status categories and naturalized or acquired U.S. citizenship. Our verification results represent point-in-time immigration status, not a full immigration history. To request a verification, registered SAVE users submit a benefit applicant's first name, last name, date of birth, and at least one unique immigration identifier, such as an A number, I-94 number, CVIS number, naturalization or citizenship certificate number, and a variety of others. For initial or automated verification, SAVE uses the information that is entered by the benefit issuing agency and compares that using a USCIS information technology service to look at that information against data that is in DHS accessed federal government immigration record systems. When we return an automated response, we return one class of admission and employment authorization information if there's any that applies to the benefit applicant. If we're not able to make an automated match, then we would do additional manual verification review that may include additional deep systems research and hard copy file research. Our SAVE manual responses include a point-in-time snapshot of all immigration applications that may be active at the time and all immigration status categories or employment authorization that exists for the benefit applicant. SAVE users can find detailed information regarding immigration documents and where to locate numeric identifiers on the SAVE commonly used immigration documents page. That page is available through uscis.gov/save. Common errors in data submission that can cause problems with automated verification or may require us to do a different type of research or ask for additional documents include not entering the benefit applicant's name and information exactly as it appears on the immigration document and transposing names, dates, numbers, or letters. One thing that's really important for people to understand is that SAVE is not an independent source system for immigration records. That means we're not a system of records in and of ourselves. We keep records of transactional data, like when cases come in and when they go out. But we rely on the information that's included in other government source systems. So in order for us to make sure that these data matches happen and where we find data mismatches, it can take us up to a 3-step process to get you the right information. If data is not automatically matched or an agency receives an unexpected result, the agency should push the case for additional manual verification. And again, this includes trained personnel reviewing the files, reviewing the information to make sure we're providing the right response. If needed, and if there's still a question after that process has been followed, a SAVE agency can reach out to their assigned agency relationship manager to ask questions or to get additional information about the process. And benefit seekers can find information about the records request process, as well as information about records requests and records corrections that they may need to make on the SAVE Fast Facts flyer or at the site you heard earlier mentioned about updating and correcting your USCIS immigration record. Thanks, Anna.
Thank you so much for that context. What steps are being taken to remedy these issues?
So we're really constantly seeking to update and improve SAFE systems. We work continuously with partner agencies to identify and address data anomalies when they arise. And we also have intake and input into the process and systems through a number of different channels. But as you just heard me talk about, the fundamental way to do this and to make sure that information is getting corrected timely is to use the SAVE 3-step process. If the initial verification doesn't produce the data match or doesn't produce the expected result, agencies should submit that additional verification request and follow through with the process so that we can do the additional research to make sure that the right information does get back to you. And if NAFSA members have identified specific cases of concern, they should please coordinate with the state user agency in the first place to make sure the agency has given the right information to SAVE, and then they can always follow up with their agency relationship manager if they have additional questions.
Thank you. Currently, when these issues crop up, the students are often told by whichever agency they're working with that it's something wrong with the SEVIS record, and they're directed back to the DSO. And as DSOs, we're pretty powerless to provide assistance if we can see that the SEVIS record is accurate. That's about all we can do. If nothing can be done to resolve the data issues, would USCIS consider additional training or resources to make SAVE users aware of the issues and how to resolve them?
Absolutely. So we do provide training and resources on this topic and it's on others for all of our customer agencies, departments of motor vehicles, the Social Security Administration, and those agencies can not only access regular and recurring trainings that we have available, but we do customized training as well for different organizations. So if there's someone who is interested in that training, they can reach out to us and we can help put that together. And again, just to reiterate, that successful SAVE verification really is dependent on the documentation and information provided by the benefit applicants. So to the extent we can ask NAFSA to please pass along the best practices for these things for folks who are applying for benefits or for licenses, it's please present your most current immigration document and make sure that it accurately reflects your information, particularly your name, date of birth, and that immigration enumerator. The most common ones we see and the ones that are I'd say the easiest for us to find in the systems are the USCIS and USCIS number or A number and the I-94 number. If you are using a foreign passport as a principal identity document and you want to use that for your immigration document as well, we also encourage you to strongly to submit a DHS issued immigration document if you have it available, or an immigration identifier. It just makes it easier to find the information in systems. And if the applicant has more than one acceptable document, I would encourage them all to take that with them to the agency so the agency can submit as many immigration identifiers as possible. The more data points we're able to match, the easier it is to return that automated response or to find the right records information if we need to go to manual research.
Thank you for that tremendously helpful information. So we're going to close just with the unified agenda for DHS has this interesting modernizing H-1B requirements rule that will address specialty occupation workers, F1, cap gap, et cetera. We're just wondering if USCIS can provide any information about its goal or intention and maybe possible timeline associated with this item.
Yes, DHS is working on a proposed rule that would amend its regulations governing H-1B specialty occupation workers and F-1 students who are the beneficiaries of timely filed H-1B CAP subject petitions. Specifically, DHS plans to propose changes to the regulations governing the employer-employee relationship and provide flexibility for startup entrepreneurs, implement new requirements and guidelines for site visits, including in connection with petitions filed by H-1B dependent employers whose basic business information cannot be validated through commercially available data, provide flexibility on the employment start date listed on the petition in limited circumstances, address CAP gap issues, bolster the H-1B registration process to reduce the possibility of misuse and fraud in the H-1B registration system, and clarify the requirement that an amended or new petition be filed where there are material changes, including by streamlining notification requirements relating to certain worksite changes, among other provisions. Thanks, Adam.
Well, thank you. And let me close the session by saying thanks very much to our USCIS presenters. We very much appreciate your time and your continuing engagement with us. Let me also say thanks to Sarah Lohman from the USCIS Public Engagement Division, who you didn't get to see here today, but who did a lot of work to make the session happen. Thanks to Adam and Hannah and your colleagues on the working group for developing the questions and topics. And thank you especially for presenting today. And then finally, thanks to all of those of you who have accessed the session. I hope you find it useful. And with that, we'll end the recording.